magician, the lover in you. Every single day, we are called to walk in our purpose. Answer the call. Lay down your burden and anything that holds you back and take your rightful place. The battle is everywhere. It's right in your face. Let's go.
Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Welcome home, family, and join us for the fun. Colorful guest people everywhere under the sun. Interesting conversations. Prayers first has begun. Invocation, manifestation, conversation, then will come. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramid. Let's start drinking some water, juice or tea. King Killer's recommended for you and me. Guayusa mixed together, maple syrup or honey. Magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Learn from the healers, crystals, pyramids. Learn from the healers, the artists, the seers, authors and teachers, dissolving your fears. Workshops of wisdom, the circle is wide. Plant medicine whispers, the planets align. All magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Crystals and pyramids, magnets that spin. Organ awakening the power within. Tantra and herbs, the gateways ignite. Shamanic drums calling truth into light. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Magnets, crystals, pyramids. Psychedelics painting vision so bright. Planetary activists guarding the night. Awareness expanding, the cosmos in view. Higher vibrations are flowing through you. Magnets, crystals, pyramids. Hey. Magnets, crystals, pyramids. Oh, magnets, crystals, pyramids. Oh,
Peace, everyone. Welcome to Moorish Monday on Magnets, Crystal Pyramid YouTube. King will be joining us in a minute or two. Right, welcome everyone. We have a powerful show for you tonight. The Beyond a Reasonable Doubt, the Mastering Evidence in Court. Beyond a Reasonable Doubt, Mastering Evidence in Court. My website, mooresandmasonry.org. For any of my books, mooresandmasonry.org. Hit that subscribe button. If you haven't done so already, hit that ding, ding, ding notification bell. Let people know that we're on live and direct. Blow the horn. Share it to your various social media platforms. Thank you for your support over the past almost 2.5 years now since I've been on Moorish Monday, host of Moorish Monday. I want to thank Brother Hank for offering this platform to me. I've brought over 40 guests on almost in a 2.5 hour year period. All right, so King should be joining us pretty soon. Raheem, give King a call because they said he'll be joining us in 2 minutes, and that was 2 minutes ago.
That knocked me off.
Oh yeah, it will. I thought you are you on your phone? Yes, it will. It will. I didn't know you were on your phone. All right. Yes, it will. So just give him a minute then. All right, so we have Brother King Albay. What you can do, Raheem, you can get started then. We'll have Brother King Albay is the guest today, and the mastering the beyond a reasonable doubt, mastering evidence in the court. All right, so Brother Raheem Albay will get started and he'll introduce himself. All right, brother, take over.
Peace and love, Islam. Many praises and honors to Allah, the Prophet, peace be upon him, Noble Drew Ali. Gratitude to Brother Hank, the Magna Crystal Pyramids. To you, Brother Abdullah and Brother King Albay, and everyone that has joined us this evening. I am Raheem Albay.
Hold on. Brother Hank, King said he's on. Hold on. King said he's up and backstage. King just text me. I continue. I'll just have to jump off and call him. Go ahead, continue.
Yeah. I am Raheem Albay, founder and president of Meeting of the Mind Civic Organization Association, executive director of Blue Horseshoe Foundation, member of the Moroccan Post School of Government and International Law, member of the Moorish Investigative and Research Committee, international human rights advocate and defender. I'm also part of the Moorish National Human Rights for Children campaign. I'll give you a little introduction of my bio. With over 15 years of technical expertise in frontline community leadership, Raheem Albay is dedicated violence prevention advocate, mentor, and licensed locksmith, committed to strengthening communities from the ground up. Brother Raheem has held multiple leadership roles within community violence intervention initiatives, including Credible Messenger, outreach worker, supervisor, hospital responder supervisor, violence interrupter, and put in the cheapest streets unit. His work spans youth mentorship, conflict mediation, hospital response, and crisis intervention, grounded in de-escalation, trauma awareness, and empowerment. Recognized for his calm presence and strategic mindset, he specializes in building trust within high-risk communities and guiding individuals, particularly youth, toward a positive, productive future. He's an international human rights activist and defender, and recipient of the Lifetime International Multicultural Humanitarian Award 2025. With a background in liberal arts and sciences, he approaches all work with professionalism, integrity, and purpose. Now I'll give a mission statement.
So that's again, King Raheem Albay is president, a founder and president of the Meeting of the Mind Civic Association.
Yes, and now I'll give the mission statement of the Meeting of the Mind Civic Association. The mission statement is to provide civic education to the New York and North Jersey areas in the studies of nationality, which entails consanguinity, ancestry, genealogy, to name a few, and legal bond to and protection of a nation state, human rights, civil and political polity, jurisprudence, which is the legal philosophy and legal principles, law of nations, etymology, which is the study of history, origin, true meaning of words, and semantics, which is the study of the change of the meaning of words. So now we will go into the action plan. Legal tools to safeguard and protect our communities. We gather not to just talk about problems, but to present solutions. Our plan of action is rooted in one fundamental principle. Knowledge of the law is power. And when that knowledge is shared collectively, it becomes protection. Our objective is clear: to create civic and educational pathways that improve the political, economic, and social conditions of our communities. We aim to do this by teaching our people the legal tools necessary to prevent and challenge discriminatory practices, including due process violations, prosecutorial misconduct, judicial misconduct, police misconduct, unethical agency practices. These are not abstract issues. These are real challenges affecting real families, real futures, and real communities. Moving forward from reaction to prevention. For too long, many of our communities have been placed in a reactionary position, responding only after harm has occurred. Our plan shifts that paradigm. We move from a reactionary approach to a preventive strategic approach. Instead of asking, what do we do now that the damage is done? We ask, how do we prevent the damage in the first place? Education is the foundation of prevention. When communities understand their constitutional protections, their procedural rights, complaint mechanisms, oversight bodies, administrative remedies, legislative channels, they become less vulnerable and more empowered. Preventive measures. Our initiative focuses on preventive measures designed to de-escalate volatile encounters, deter discriminatory actions, diminish systemic targeting, solve prejudicial situations before they escalate. We educate our people on how to properly document incidents, file complaints with the appropriate local, state, and federal agencies, pursue civil remedies and lawsuits where necessary, engage legislative representatives, advocate for policy reform. This is not about confrontation. It's about lawful strategic engagement. It's about understanding the system well enough to navigate it effectively, stopping the corrosion. Unchecked misconduct corrodes trust. Unchecked discrimination corrodes opportunity. Unchecked targeting corrodes entire communities. Our mission is to stop that corrosion. We do that not through rhetoric, but through structure, through education, through lawful action, and through organized civic engagement. Pathways to remedy and resolution. Every problem must have a pathway to remedy. We are building clear pathways to administrative resolution, judicial remedies, legislative reform, community accountability, policy transformation. We are building a culture where our communities know where to go, what to file, who to contact, what timelines apply, what standards must be met. And most importantly, we build a culture where our people understand their rights before those rights are violated. So in closing, this is about safeguarding our communities. This is about strengthening civic literacy. This is about transforming vulnerability into preparedness. When we teach legal tools, we build protection. When we build protection, we build stability. When we build stability, we build power. This is our plan of action. Legal tools, civic education, preventive measures, pathways to remedy and resolution. When unity and knowledge comes together, it becomes an unstoppable force. Gratitude.
All right, so there's a couple of upcoming events.
So our first event that's coming up, Meeting of the Minds and Luisa Flores presents Civic Education Lecture Series with King L. Bay. The topic would be legal tools, learning legal tools to protect and safeguard our community. Learn due process to handle legal cases, learn how to address prosecutorial misconduct. Why should you know the rules of the court? What is the role of the prosecutor and judge, and how to read statuses? This event is April 2nd,
It's the statutes.
2026. Excuse me?
How to read
How
statutes?
to read statutes. Pardon. This event is April 2nd, 2026 at the Ambrose Ward Mansion, Ambrose, AMBROSE, hyphen Ward, Mansion, 132 South Harrison Street, East Orange, New Jersey, 07018. And that event is from 5 p.m. to 8 p.m. You can contact myself, Raheem Allah Bey, telephone number 347-832-9875. Again, 347-832-9875. This is a free event in East Orange, New Jersey. Our second event, Meeting of the Minds Civic Association in Louisa Flores presents Civic Education Lecture with King El Bey. It will be the same topic. May 16th, 2026 at Lux Venue, LUXVENUE, Lux Venue, 122-13 Guy R. Brewer Boulevard, Jamaica, Queens, New York, 11434. This event starts at 11:30 a.m. until 4 p.m. This is a paid event, $25 for the ticket. I urge everyone to get their tickets now. They're running out. Again, it's a paid event at Lux Venue in Jamaica, Queens. Again, my contact number is 347-832-9875. You can see this is the flyer to the first event. And this is the second flyer for the second event. But if you get in contact with me, I'll be willing enough to send you the flyers and or speak to you about any of the events.
Now, King El Bey and I will be in Hardyville, South Carolina on August 16th at the Aguape Life Center. That's from 2:30 until, I think, 10 o'clock. And that is, what, $30 the door. Get your tickets. My number is 215-300-5471. I can get you. I'll post the flyer again on my Facebook page. So that's August 16th, and we're looking to have a few other events before, even after. We're looking to have set up a 4 or 5 city tour: Camden, Philadelphia, Wilmington, Jersey City, Queens, possibly East Orange. You know, because that's a context of growing daily. All right, so Brother King has 2 books that'll be coming out soon. But King, before you get into the main topic, give us an overview of your 2 upcoming books.
Okay, the first book, well, this would be, let me see. So, still putting this together. The title.
The legal formula, a understanding, the legal formula, a guide to understanding the law, or something like that.
That's the second book. It's
Well, that's one of the books. Yeah, legal formula, a guide to understand.
Yeah, it's
understand.
The legal formula, the method of understanding law.
All right.
And then the second one is going to be due process and other topics dealing with due process and that. I'm still working on.
You're still working on deciding on the title for that book. All right. So this tell us about the legal formula, a method for understanding the law.
Well, the legal formula is a structure. Is based in legality, based on philosophy, and how philosophers created legal principles, and where these principles set a guideline, a basis of understanding that legal topic, what you're trying to address. So you have the philosophy, right? So when they go about creating law, it's based on a legal intent, an understanding of purpose. So it was a lot of thought behind this. So this is where equity comes from. It's based on philosophy. This is where all law starts. It starts in the mind. It starts with discussion. So now, how do they shape society based on the common law? That's what the common law in England. People became aware of some of the things that was plaguing their community, and that they wanted to resolve these issues. So that's the philosophy. The philosophy behind it. You had a lot of philosophers like Aristotle and other people who sat down and thought about life and looked at life through a legal lens, and they created these philosophies. And through these philosophers, they created these philosophies. And then when you look at how law is rooted and the constitutions and all of this is based on a certain mindset, certain type of philosophy. Now, this philosophy created a principle. Now, every law, even common law, judge-made law, to statutes is based on a principle, a philosophy that creates a principle. This principle is made up of elements. These elements are the DNA of a principle. This is how you know how you thinking proper when you're dealing with legality, because you will know that you're staying on track. Then these elements, right, what they use is evidentiary standards based on the rules of evidence, how that American jurisprudence look and examine evidence, determine its credibility based on its inadmissibility and admissibility. And that become a tool for the findings of facts. Once an element is discovered, it becomes a fact in the case, which trigger either the statute or that common law. This is a legal structure that you can easily follow. Nobody has been teaching these principles. This is why our community kind of got lost. Once you understand the findings of facts and you got the facts based on you following this formula, right? Then now you can look at what the law has already concluded. You can go back in history and look at what they've done under American jurisprudence before, and now you can see the mindset of the people in which they was thinking about, and say, okay, based on this, this is similar to this case or that case. That person is owed that same remedy. This is where equal protection comes in. So once you understand the philosophy, which is you find out the intent and purpose, then you'll find out the principle. And the principle, the core principle, is made up of elements. Those elements is like DNA, in which you can know that you're right within that particular principle. Then you understand how those elements make up that principle. Then you can look and say, okay, now did they meet what? These elements. Like if you get a statute charge, a charge with, let's say, carrying a concealed weapon, that the core principle behind it, I know one of people gonna say intent, but there's other elements. Why? Because that statute was based on a legal intent and purpose, and it was designed for a certain reason. And that principle created these elements. If those elements don't exist, then that statute can't be applied. There's no facts that then the prosecutor can use or the state can use to charge you with that statute, because those elements did not exist. All those necessary elements did not exist in that statute for you to be charged. Now, based on that, you can look at the findings of fact and say, since they don't exist, now the law has already concluded that there can't be no any charges. They have to drop them. And based on somebody else's case that they looked at that same who was charged with that, say if it went to the Supreme Court gonna analyze it based on the same knowledge and understanding. Like, this is a structure that most people don't have, that they need to follow. And the formula breaks it down. It explains things to you to make it more simplified. So now you can understand how to think proper when dealing with law. People ask me, King, how did you know how to deal with that case? Or how did you understand? I've used this formula. I used these principles. I stayed within the legal framework. I didn't go outside and start creating my own sense of understanding. I used what was already there that it exists, what they told me to use. I read it, I examined it, I analyzed it, and I said, okay, this is how you understand, right? So once I understood how statutes was created, how common law was created, and I looked at how the history of law was birthed, I looked at it. See, most people don't understand all areas of law is based off in equity. Due process is equity.
Oh, shucks. It got bounced off. You there, Raheem?
Yeah, I'm in.
All right, good. So yeah, he's got bounced off. Brother, we'll try to get Bill kick it back on. Brother Hank, are you there? Let's get back in. Peace, everyone. Welcome. Those who are just joining us. This is Moorish Monday with Abdullah Il Talib Mosi Bey on Magnets, Crystals, Pyramids, YouTube. We're waiting for our guests to come back on. My website, Moorish and Main Street, is moorishandmainstreet.org. Hit that like button. If you haven't hit that subscribe button, please do so. Hit that ding, ding, ding notification bell. I'm waiting for him if he texts me if he's backstage. And I have to. All right, let me, brother Raheem, can you read? You've already read your you were at the United Nations, Raheem. The 2 days last week. Then a couple of days the week before that.
Yeah, on the commission on the status of women's
Yeah. So once
suffrage.
you talk about that, talk about your visit at the United Nations, and I'll have to jump off. All right.
Well, basically, my experience at the United Nations, I made good connections with the women from other nations, other organizations. You know, they were being honored for their works in their respective territories and their communities. I met fabulous women that have been doing great works for the women in their communities. It was a week, 10-day event where they held several events in New York, also in the United Nations. So basically, that's pretty much what I did. I made strong connections, though. You know, our main focus is to connect with organizations that have already boots on the ground and ties to the community, where we can help educate them and help be more effective in bringing resources and remedy back to the community. So a couple of things we'll be addressing will be like the rules of evidence, knowing how to structure affidavits, motions, pleadings, and exhibits, making it organized and uniformed for a judge to follow. Rules of evidence, how to enter evidence into your case. Evidence has to be reviewed by both parties. You must give the other party the opportunity to have a defense. That's very important. Failure to adhere to the rules would disqualify your case. We're also learning how to object to evidence when evidence is not relevant and has not adhered to the procedures. So learning when evidence is admissible or inadmissible, when it has not been authenticated by a primary source. Learn when evidence is hearsay and has no primary source, which should not be admitted into evidence. Also have to know that all evidence must be authenticated. A source or credible person must identify that they have firsthand knowledge of such evidence. If performed by an expert, then the expert must have that proper credentials and support. And then you have to know failure to object about any unqualified evidence can be detrimental to your case when it should have never been entered into the first case. You know, it can affect both sides. So these are things that we'll be touching on in the workshop, in the, you know, in our events. Go into a little bit about the logistics of the community center and operational framework. Structure, implementation methods, operational detail, and training mechanisms for the Civic Education and Legal Assistance Center framework. The purpose and vision of the Civic Center is designed to function as a community-based civic education and legal assistance hub. Its primary purpose is to educate, train, and empower individuals with knowledge of law, procedure, and civic rights, while also creating a structured system for assisting community members facing legal issues. We established a structured civic center. The civic center should operate similarly to a legal education institute and community legal support clinic. The core objectives are provide structured civic and legal education, offer guided assistance for individuals navigating legal systems, create an organization, consultation, and intake system, train community members to become knowledgeable legal assistants. Let me read this one more, King, and I'm gonna let you take over. Operational structure: the center should include educational divisions, civic educational classes, legal literacy training, constitutional and procedural law instruction, consultational division, intake interviews, case assessments, consultational scheduling, legal assistance division, documentation support, research assistance, procedural guidance. And I yield and let King take over.
All right, we back. You have your other book, your second book, King, with due process, evidentiary, evidence, constitutional safeguard.
Yeah, I'm writing a book. So the book is let me go over some of the stuff in the book.
Mm-hmm. You got the sun glare. The sun glare is ending. It's your eye can't see your eyes. It's glaring.
Is it sun glare gone now?
Let me see. Yeah, it's good. You're good.
So
it's better.
In this book, right? I'm trying to see what I'm trying to put the. Let me pull up the book. So
as you look, all right, go ahead.
So I'm trying to.
All right, welcome everyone who's just joining us. This is Moorish Monday with Abdullah El Talib Mosi Bey on Magnus Crystal Pyramids YouTube. My website is mooresandmasonry.org. It's shown across the screen. You find it, King?
Yeah, this book.
All right.
So let me get into some of this, the due process. So this is the introduction. In the intricate world of law, the difference between winning and losing a case often hinges on a few fundamental principles that many overlook. This book is designed to be your guide through those principles, especially they apply to rules of evidence and crucial protection of due process found in the 4th, 5th, and 14th Amendments. Why start with the rules of evidence? Because evidence is very foundation upon which every legal case is built. Knowing how evidence is gathered, weighed, and either admitted or excluded is critical. Without understanding these rules, navigating the legal system is like moving through a maze blindfolded. But evidence is only part of the equation. This book would explore profound relationships between the rules and evidence and due process clause clauses of the Fifth and 14th Amendment. These amendments ensure that no individual is deprived of life, liberty, or property without due process of law. By understanding the procedural and substantive due process, you will see how these principles work together like a well-oiled machine to protect fundamental rights and shape the outcome of a case. So, and then it says, in these pages, you will learn how the rules and principles can be used not just to build a case, but to dismantle weak ones, revealing when the state has overstepped its bounds. You will find practical examples, hypothetical scenarios, real-world applications that will illustrate how mastering these concepts can be a game changer in the courtroom. Welcome to the journey that will empower you with the knowledge to navigate the legal system with confidence, armed with the principles of evidence and due process enshrined in the Constitution. So, I just want to let y'all know, this book doesn't constitute legal advice, but it's powerful. And working on this title, right? This book is going to bring us to really understanding the law, not from a pseudoscience or misrepresentation of law, but based on real litigation, real expertise as a pro se litigant, how to move the court, how to properly motion the court, how to properly take action. It's only one form of action that they tell you in the civil rules of procedure. It's only one form. This shall be known as the civil action. The inferior courts deal with civil actions. It tells you can use when you ask the court, the Constitution don't say nothing about civil actions. So where do civil actions come from? Out of force, perspective, jurisdiction, common law, equity, maritime, and amity. Those are the four mentioned jurisdictions within the Constitution of the United States. In any other jurisdiction other than territorial, that's based on sovereignty, right? That's an international claim, right? In which embody all of this American jurisprudence. Without territorial sovereignty, they couldn't do none of this. So you got to understand the legal framework and how all of this is integrated and how these moving parts is working. You got to understand the international piece as well as the domestic piece to do what? Keep you in sync with the legal framework so that you don't step out of bounds. The book is going to teach you like playing football. When you playing football, you got to know where the end zone to end zone. You got to know what's out of bounds. You got to know what's a flagrant foul. You got to know that you can't grab the face mask to tackle. You got to know these rules. These rules in this book is teaching you the elements of what you need to know so that you don't have to go in there unprepared. It'll give you the foundational work that you need so that you can be able to now critically think when you get in and examine what's going on with the courtroom. We don't have to sit up there and say, well, I didn't cross the bar. All of these different things that they're telling you to do that doesn't make no legal sense to the court. And the court is just looking at you like they bewildered. So now they start questioning your mindset. Now they start locking you up because they feel like you're incompetent to be in society because of your mindset. And they have a duty to protect society, to protect people from mental ill people moving in society. Yes, they do. They have a right to protect the public. And the public don't necessarily mean you and me, it means government interests. We are all in the interest of government. Why would you say that? Because government created taxpayers. Each one of us is a taxpayer that what? Fund this government and fuel this government. Help with us taxpayers help build infrastructure so this government can function. Through taxes, schools, levies, they have schools, bridges, toll bridges, roads, garbage, anything that you can think of, right? Taxes. So they have a right to protect that. So learning this book, I'm gonna have a good name for it, right? Due process and the rules of evidence and how they work together. You're gonna get a good name for this book. It'll be ready soon. I got both of these books pretty much done. They're gonna be ready really soon, and you will have them for purchase. These books will show you why you need to understand the legal formula and why you need to understand evidence and the due process. And I'm definitely be coming out with equal protection. You guys need to understand the foundations of these rules. I'm gonna be talking about the rule of law that most of y'all don't understand. I'm gonna be talking not just due process. I'm gonna be talking about application of law, source of law, operation of law, all of these different things that most of us not talking about because they're not what? Litigators. I'm talking about dealing with some heavy hitting information. You understand
No,
what I'm saying?
thank you, brother. I'm glad. Yeah, that's much needed. That you we have this. All right, so these books will be available soon, coming your way soon. Ding, ding, ding. All right, all right. So we have the main topic, the beyond a reasonable doubt, mastering the mastering evidence for the court. Beyond a reasonable doubt, mastering evidence for the court. Uh, do you want did you just get into it, right, King? And then Raheem has some notes that he you dictated to him earlier. Do you want him to start with that? How you want to do this?
I read those during y'all break, but I can read
Yep.
it again.
You will read them again because it'll be embodied in what yeah.
Well, since he started already, let's go ahead and get started with some of that stuff.
All right, yes.
And then I break into some of these rules and what we need to be thinking about when we're looking at these rules and understanding these rules.
You want you want to read? What Raheem to read first or what?
Read first. Read first.
Go ahead, Raheem.
All right, so let's start with the rules of evidence. Know how to structure affidavits, motions, pleadings, and exhibits, making it organized and uniform for a judge to follow. Rules of evidence, how to enter evidence into your case. Evidence has to be reviewed by both parties. You must give the other party the opportunity to have a definitive defense. Failure to adhere to the rules will disqualify your case. Learning how to object to evidence when evidence is not relevant and has not adhered to the procedures. Pardon. Learning when evidence is admissible or inadmissible when it has not been authenticated by a primary source. Learn when evidence is hearsay and has no primary source which should not be admitted into evidence. All evidence must be authenticated. A source or credible person can identify that has firsthand knowledge of such evidence. If performed by expert, then the expert must have the proper credentials to support the evidence. And failure to object about unqualified evidence can be detrimental to one's case when it should have never been heard in the case. It can affect both sides.
So when we're talking about evidence and the rules of evidence, so let's click on, I'm going to go over some of this stuff, why it's important to understand it, right? So it says record of offer and ruling. This is one of the rules. At the time of making the ruling, the court may add any other or further statements which shows the character of evidence, the form in which it was offered, the objections made, and the ruling thereof. It may direct the making of an offer in question and answer form. Y'all got to understand this. Plain error. Nothing in this rule preclude taking notice of plain errors affecting substantial rights, although they were not brought up to the attention of the court. So the appeal court, but you want to make sure that you identify this because they're not going to identify it for you. Hearing of jury. In jury cases, proceedings shall be conducted to extent practicable so as to prevent inadmissible evidence from being suggested to the jury by any means, such as making statements or offers of proof or asking questions in the hearing of a jury. So you got to know these rules, like objection. In the case the ruling is one admitted evidence, a timely objection or motion strikes appears on the record stating the specific grounds of the objection. If the specific grounds was not apparent from the content or offer of proof in the case, ruling is one excluding evidence. The substance of the evidence was made known to the court by offer or apparent from context which the questions were asked. Offer of proof is not necessary if evidence is excluded during cross-examination. So we talking about preservation of evidence, understanding Brady discovery, understanding how to preserve evidence, and understanding the evidentiary rules that govern such practice when presenting evidence. You got to know how to present evidence. You got to know how to preserve evidence. So if you don't know these rules, then when you come into court and you're trying to present evidence, your evidence can be challenged because you're not adherent to the rules. Like if I got some evidence I'm trying to present, then I gotta forward it to the other party by certificate of service or affidavit of mailing showing that what? That I served the other party. Why is that crucial? Because that is very crucial so that you can show the court that you adhere to the rules of evidence in civil procedure or criminal procedure when you're doing your evidentiary practice, right? Showing that you align with the rules so that your evidence won't get disqualified for non-adherence to the rules. You got to know these techniques. You got to know how to utilize, like in a criminal case, I think it's Ohio Rule 59, how to utilize interrogatories and admissions. When the criminal rules don't give rise to this, you can always look at the civil rules because there's only one rule. It's only one form of action in the civil rules. It says there's only one form of action. It shall be known as a civil action. The rest of the court, this is civil actions. They didn't say civil jurisdiction. They said civil action because the Constitution never mentioned civil jurisdiction. And if you don't understand the difference between the two and don't understand how the court is moving, then you won't be able to articulate a strategy and articulate your motions and evidence pleading through this process. You must understand these rules. So let's go back to the rules of evidence, to the scope of the rules. What is considered admissible? Okay, so let's look at the scope of the rules. It says scope of the rules, applicability, privilege, and exceptions. It says the rules governing proceeding in the course of this state subject to the exceptions stated in Division D of this rule. Privilege, the rule will respect to privilege applies to all stages of actions, cases, and proceedings conduct under these rules. I don't want you to get misconstrued thinking that a civil action is the same as a civil jurisdiction. They're not the same. Civil rules is not the same as civil jurisdiction. You need to know the difference. Because you got to understand that you have to know the language that's being used and how this language defines how things is moving. So you would know how to respond and think proper when dealing and talking to the court, understanding the rules of evidence. So you got to understand these rules. So now we're going to the scope of the rules we went through. Now, what is the exception to these rules? These rules, other than with respect to privilege, do not apply in the following situations: determining prerequisites to rulings on the admissibility of evidence when the issue is to be determined by the court under Evidence Rule 104. Why is they talking about 104? Proceedings before a grand jury. You got to know that these rules don't apply when dealing with the grand jury or dealing with admissibility of evidence and how they go before the judge, right? Because the judge allow and disallow evidence. The rules of evidence do not apply when evidence is being presented. The judge has to use his wherewithal. Now, once the evidence be presented based on the rules and you followed it, because the court make the decision on the admissibility and the what? The admissibility and the inadmissibility. To understand its relevance, if it's relevant to the case, the judge use his legal knowledge to make a determination on the relevance of the evidence. So you don't get to present anything to the court. The court ain't gonna allow you to present anything. It got to be weighed. What I mean by weighed, the court got to look at it. Like, for example, if you try to present a affidavit without the party authenticating the affidavit, what do that mean? That person who created the affidavit got firsthand knowledge on why he made that affidavit in that statement. Nobody can qualify his affidavit but the original person who wrote it. So that person got to come in to be what? Cross-examined. Or that evidence can be used, his statement can be disqualified. Because what that do is that cheat the other party from making an affirmative defense because they can't cross-examine the person who created the affidavit. That's a violation of due process. You have to understand these things. Like, I got so much legal years in that I understand. I know when to look at due process issues. I already know how to challenge evidence when they spoilage of evidence. Let me see if I can find a motion. Let me show y'all. I'm going to read y'all a motion that let me see if I can find it.
Hit that like button. Hit that ding, notification bell. Let the people know we're on. We got an hour, 8 minutes left. It's heating up, y'all. Beyond a reasonable doubt, mastering evidence for the court.
Okay. I'm trying to
My website, mooresandmasonry.org. Thank you all for joining us this evening.
Okay.
You ready? Mm-hmm.
Got this motion. Let me see. I'm just going to show y'all how this motion is. It says, defendant motion to compel discovery to preserve and produce electronic law enforcement data and for appropriate relief. So that one, let me see, where's the other one? So
Jazz iPhone.
So let me see. I'm trying to. So that one, right? So we talking about interviews, interrogations and records, body cam vehicle and surveillance footage, law enforcement reports and medical material, warrants and probable cause. So I'm just going to break down some stuff that you need to understand, like You need to understand spoilage, spoilage of evidence. Spoilage of evidence. Everybody want to call me now. I'm trying to find it, but I'll find it. So when we looking at spoilage of evidence, so when you asking for a Brady discovery, right? You looking for Brady material under Brady, right? Brady law. That's a common law. And you asking the court for like a KDT, MDT, chatterbox. Most of y'all don't even know what that is. Those are the devices that's used when over those police scanners. That when a crime is go out, they got that under some type of transmission and it's codified. You can get that chatterbox. You can get all of that. That chatterbox is in their car because before a lot of times when they pull you over, right, they run your stuff through and it all come back. You can get all of that recorded information. A lot of y'all don't know to do that. What is a KDT and MDT? What is the chatterbox? These are all the things that they be using those devices. Most of y'all don't, and then they come in a code. Then you ask like something. I remember one time I asked for that. They gave it to me in the code. I said, no, I need this transcribed. So they didn't do it. So I asked for a motion for sanctions. Because I already put in that a supplementary motion for discovery for the transmission of this being decoded, that they gave it to me codified, and I need this now to be translated into regular language. Due to that, I can't read this code. And I asked the court and I put sanction, I gave them 30 days. So they kept giving me this water around. So I started asking the court for a motion, right? I asked the court for the compel of the discovery, and then I put a motion for sanctions in with that. And when they went to the court, they got to show good cause why they don't got this. Why I haven't? The court gonna give them a deadline. Well, y'all got to have this in by 30 days. He put this motion in. Y'all got to have this. The court cannot go back on his word without showing good cause. The judge is a referee. He cannot extend a courtesy to the prosecutor and make an excuse for the prosecutor because ignorance of the law is no excuse. That goes for everybody. And you got to know when to object when the judge be doing it because they do that all the time. Well, I'm looking at this motion and he put sanctions in the prosecutor. And I'm like, Your Honor, he's overdue. He's 90 days in. He's a legal professional. He has a degree in this. So I'm not accepting. He got a whole legal department that he's working with. He's working with the police department. They got experts that know how to do this. I'm not accepting that, Your Honor. I'm objecting. Well, your objection is overruled. Okay. And they're going to keep moving on with the case. You got to know what to do from there. Now, you throw something else at them. They still doing the same thing. They overrule. Now you hit them with a motion to stay due to due process violations. You get what I'm saying? And now you asking to file an injunction to stop the due process. There's too many due processes. Because you can't just file a motion just to file a motion. You got to have just cause. You got to, when the appealing court hear this, you got to learn how to object. You got to learn how to produce and sustain and to protect and preserve evidence. If you don't know how these rules work, you ain't going to know how to enter evidence. You ain't going to learn how to preserve evidence. You ain't gonna know what to do when these scenarios and situations come about. You got to have the experience and knowledge and know-how to deal with the court. You got to have the knowledge and know-how, and you got to know these rules because these rules are unforgiving. You cannot overlook and say, I don't need it. I'm just going to use the Constitution. No. You got to know the rules of civil procedure if you're in a civil case. You got to know the rules of evidence. You got to know the criminal rules of procedure. You got to, in Ohio, you got to know the rules of superintendent. You got to know the local rules because these rules are very unforgiving. Fair to adhere will get your case, get you not to make a stance or defense. This will get you banked. And the Supreme Court already said you don't get a second bite at the apple. You don't just get to keep filing just to keep filing. They like you locked out, you barred. Why are you barred? Because you didn't file it within the rules. You wait till the statutes of limitation based on these rules started to activate, and now you time barred. Now we can't hear it because you don't show good cause. Then you got to have a damn good reason why you filing it out of time. Motion for out of time. Was you in a hospital in a coma? Did you have a car accident? Was you sick? You better have some kind of excuse that the court would look at. It's called excusable neglect. Look it up. Everything I talk about, you can fact check. I'm talking about these rules of evidence, evidentiary standards of practice. I didn't make these rules up, they did. You got to know how evidence is weighed. So it's weighed in credibility. This rule does not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. How do the court weigh evidence? They look at the source, where it's coming from. They look, can somebody validate this, especially if they give a statement under oath, right? You better know how to use affidavits. You better learn how to use certain things. You better learn how to use this information and understand these rules of evidence. I'm going into the rules of evidence, but there's many rules that you got to learn. Why am I starting with the rules of evidence? Because evidence is what the jury weigh. The law don't come in. The law come in, always the facts come in before the law. Facts weigh heavier than law. Why? Because it's the facts that trigger the statute. The jury ruled on the facts. They don't rule on the law. They don't make no legal determination. They determine your innocence and guilt. And then the judge determines how he's going to apply the law. Most of y'all be in there arguing legal stuff and y'all know the operation of law. Facts come before law. Why I say facts come before law? Because if you ain't got no facts, you can't charge me with no crime. The judge can't make no ruling, no common law ruling, no statutory ruling, nothing. Facts come first. What is facts? The facts is this. The facts got to align with the elements. What do you mean, King Albay? That principle birthed out elements. It gave birth to elements. If those facts don't align, and every statute and every charge have a particular set of elements, and if those facts don't align with their elements, and you can prove that those facts don't, then I don't care if they mischarge you, they don't have the right statute to charge you with whatever. So that charge could get dismissed. Now they could come what they call a lesser included, a lesser charge, right? But those same elements got to exist. So they might say instead of murder, they hit you with manslaughter or second-degree manslaughter, right? They bring it still fall under, murder, but it's different forms or different kinds of types of murder. That's why they got justifiable homicide. Why is it justifiable? Those that have a certain criteria, circumstances, or elements within their statute in which must be met. Failure to meet that, then the threshold, you can't meet the threshold. What is the threshold? Beyond a reasonable doubt in criminal law. That's all dealing with the evidence, because the evidence is what's going to steer you to what we call facts. The facts and elements is pretty much the same, but you got to have what? They got to meet the what? The elements. If you don't meet the elements, then you're not going to meet your case. You got to know how to you got to learn how to deal with this information accordingly. See, a lot of us, so I want y'all to understand, most of us don't lose our case because we come in there with the truth. Most of us lose our case because we don't know the rules, we're unprepared, and we're not qualified enough to be there based on our lack of knowledge. Lack of knowledge. We go into court and we don't know how to deal with the court. We don't know when to object. We don't know how evidence is supposed to be introduced. The prosecutor over there introducing all types of evidence. Like, for example, the prosecutor might say, right before the day of trial, here's his witnesses. And according to the rules, and he's supposed to file that 7 to 10 days before trial to give you a right to do what? Review the evidence or review his witnesses and who's going to be testifying. To give you a chance to look at this, right? A lot of us don't know that, so we get into court and this key is going down. And now the jury done heard it. You ain't object to it. You ain't put in no notice of objection. You ain't put in a motion for objection, or you ain't even put in a motion to strike. Kerner versus Hearns. The court is not allowed to judge or scrutinize a pro se litigant as the same as an attorney. They must give leeway to your pleadings. If you don't understand how to utilize all these moving parts, all these different tools, then you're going to be in trouble. Most of us don't understand these rules, so you better know these rules. You better learn how to look at these rules. You better become very acquainted with these rules, because these rules is very unforgiving. They're unforgiving. So let's look at function of the court and jury. This under evidence rules. When the admissibility of other evidence of content of writing, records, or photograph under these rules depend upon the fulfillment of a condition of fact. You see that? Fulfillment of a condition of fact. The question whether the condition has been fulfilled in ordinarily for the court to determine in accordance with the provision of Rule 104. However, when an issue is raised, whether to assert it in writing ever existed or whether another writing, record, or photograph produced at trial is the original, or whether the evidence of the content correctly reflects the content, the issue is for the trier of the fact to determine in the case of other issues of fact. Let me read that to you, that last part. However, when an issue is raised under A, Part A, whether the asserted writing ever existed, one, that whether another writing, record, or photograph produced at trial is the original, two, whether evidence of contents correctly reflects the content, the issue is for the trial of the fact to determine as in the case of other issues of fact. Y'all got to know what that means. Y'all got to know what that means when they talking about trials looking at this evidence. So they talking about how evidence is what? They talking about evidence and its admissibility based on if the writing ever existed, if this was made up, if writing, records, or photographs produced at trial was the original, was they copies, and whether the evidence of content correctly reflects the content. If the evidence that you presented, do it present or the content of the evidence that you try to support. The issue is for the trial of fact to determine as well in the case of other issues of fact. So who is the trial of fact? The jury, not the judge. The judge allowed evidence to be introduced based on admissibility and relevantness. But the trial of fact is the jury, and they have to discern if all of this information, did you connect the dots? Is this evidence, right, says what it is? Is it everything what it is? You guys got to understand these rules and understand how evidence is preserved. So we got to know what is spoilage of evidence. That means that evidence, for example, right? I asked for the KDT and MBT and certain other relevant evidence, chatterbox, and they allowed the evidence to get erased or lost, and they didn't preserve it. And you asked it within a timely frame, and they said, "Yeah, we're going to get the evidence," and they lose it. The mishandling or tampering with evidence. So they was planning on using some evidence. Now let's say they made a copy of something of the evidence or whatever, a picture, a weapon or whatever. That has to be authenticated. The experts got to say that's the same gun. Now you can sit up there and say, no, that ain't, because they might have a picture of you with a gun trying to corroborate this evidence that they took because they done lost and misplaced the evidence. Now they asking for evidence to do what? Try to use you based on the picture or whatever, and they don't have the same serial number or nothing. They don't have anything and no record of it. That don't mean because a gun may be the same type of brand and model, that don't mean it's the same gun. You have to understand a lot of this information, family. Let's get more into these rules. I'm going to break down preliminaries, ruling on evidence. Let's say ruling on evidence. Effect of error ruling. Error may not be predicted upon a ruling which admits or excludes evidence unless a substantial right of the party is affected. Right? Y'all got to know this. Objections, I already went over there. Offer of proof, y'all got to do this. Once the court ruled definitely on the record, either it says, once the court ruled definitely on the record, either before or at trial, a party need not to renew an objection or offer proof to preserve a claim of error for appeal. You gotta let these court know you don't gotta keep doing it more than once. You gotta know these rules. So let's go up to the other rules. Y'all gotta know these rules, man. Y'all got to understand the rules of rules. So let's go here. Judicial notice of adjudicated fact. This rule governs only judicial notice of adjudicated facts, i.e., the facts of the case. A judicial notice of fact must be one not subject to reasonable dispute, that is, either generally known within the territory of the trial court or capable of accurate and ready determination by resort to sources whose accuracy cannot be reasonably questioned. Let me read that again. Judicial notice of adjudicated fact. Scope of the rule. This rule governs only judicial notice of adjudicated facts, i.e., the facts of the case. A judicial notice fact must be one not subject to reasonable dispute in that it is either generally known within the territory of the trial court or capable of accurate and ready determination by resorts to sources whose accuracy cannot be reasonably questioned. Why I read that? Why I'm talking about that? Because when you introduce case law, all of these different things, statutes, rules, or violations, you got to cite the source where you got it from. Why? Because now the court got to determine what? The source of law, to determine the credibility of the law. Like you might have a case, let's say you got a case that, uh, let's say, there was, give you an example, like, let's say you won a case in Kentucky, right, against a person that live in another state, like Ohio or whatever. And the court is going to weigh evidence when you start bringing some other stuff. Let's say you found something, like you brought a civil case, they did something in Kentucky, they fled to Ohio, and now you got them in Ohio on some stuff, on some issues that they was doing that violated some rights and some contracts, and now you wanted to use that judgment from Kentucky. The court is going to look at it and determine if it's real or not. They're going to fact check it, and then they're going to give it weight or evidence. Because if it comes from them, it's a credible source. Or it comes from an affidavit from you or somebody else, the court going to look at who you are, look at your criminal record, determine if you credible or not. You have to understand how this stuff works. You have to understand why you need to know the rules of evidence. So, time of taking notice. Judicial notice may be taken at any stage of the proceeding. I need y'all to know that. Judicial notice can be taken at any stage. What does that mean? If you get a court, judicial notice is something that it come in at the stage of the proceeding. They can't. You can use that at any given time, family. My apologies. So I'm just trying to get something established so y'all can start understanding why these rules are so important, because they unforgiving. Failure to adhere to the rules, you're gonna have some trouble if you don't know these rules. So let's go through jury instructions. In civil actions, these are all rules of evidence. The court shall instruct the jury to accept a conclusive any fact judicially noticed. If in civil actions or proceedings, the court shall instruct the jury to accept a conclusive, any fact judicially noticed. In criminal case, the court shall instruct the jury that it may but is required to accept a, as conclusive any fact judicial notice. And let me read that over. In a criminal case, the court shall instruct the juror that it may but is not required to accept as conclusive any fact judicial notice. So what is that telling you? The juror don't have to accept certain things in criminal case for as judicial notice dealing with certain types of evidence. They don't have to. They can use their own discretion. So you got to know that about the rules. We got to stop not knowing going into court unprepared because most of us don't know these rules. We don't know what is relevant rule, what is the privilege, attorney-client privilege, religious privilege between you and your minister or priest or whatever. You gotta know the hearsay rule, availability of declared immaterial evidence. You gotta know all of these. Hearsay within hearsay. You gotta know that. Self-authentication. They got requirement of authentication or identification. Let's look at this. Extrinsic evidence of authenticity as a condition preceding to admissible is not required with respect to the following. These are the following type of evidence. Domestic public documents under seal. What is that? Like affidavits. A signature purporting to be attestation, that's an affidavit. Domestic public documents under seal, a document purporting to bear the signature in the official capacity of an officer, employee of any entity, including a paragraph hereof, having a seal in the public, officers having a seal and having official duties in the district or political subdivision of the officer or employees certified under seal that the signer has the official capacity and the signature is genuine. Foreign public documents. A lot of y'all get this misconstrued. A document purporting to be executed or attested in the official capacity by a person authorized by law of a foreign country. A lot of y'all get this misconstrued because y'all think that we got a state and y'all is a foreign country. To make the execution or attestation and accompanied by a final certificate as to the genuineness of a signature and official position. A, of the execution or attestation of a person or of any foreign official whose certificate of genuineness of a signature and official position relates to the execution or attestation or is in chain of a certificate of genuineness of signatures and official positions relating to the execution of attestation. A final certificate may be made by the Secretary of Embassy or litigation, Consul General, Consul, Vice Consul, or Consul Agent of the United States, or domestic or consular a consul officer of a foreign country assigned or accredited to the United States. If reasonable opportunity has been given to all parties to investigate the authenticity and accuracy of the official document, the court may, for good cause shown, order that they be treated as presumptively authentic without final certificate or permit, then be evidenced by an attested a summary with or without final certificate. So a lot of y'all believe that we are foreign and we can do all of this stuff under this jurisdiction, and we just can't. We got to know the rules. These rules get very deep and intrinsic. You got to know the rules. You got to know how to navigate through these rules, how to spot rule changes when somebody is not adhering to the law and they start trying to tell you this and tell you that. You got to understand how this works, family. So I'm gonna get into a little bit of this book, a little bit. We're gonna talk about. So I'm trying to find something to read from. It's a lot in this book.
Y'all have any questions? Type your questions in. Question in the comments. I've been reading the comments. I think we have one question. I've been reading the comments. We have a question here, King.
Okay, what is it?
All right, Jeremy Bay. Is there any effect on how the evidence is obtained against you that would make it dismissible? Like if a cop violated your rights to receive such evidence without any proof of a threat to the public. Do I need to reread that?
No.
Are you good? All right.
So they gotta have police officers would have what they call qualified immunity, right? Qualified immunity, and they got to adhere to these constitutional principles. Everybody does. Nobody is above the law. So let's say they obtain evidence by by failing to adhere to constitutional protections. Certain things, right? Let's say like under Terry, right? The officer allowed under Terry versus Ohio, they allowed to frisk you, but they got to have understand what probable cause is. So, in order for you to understand, I'm gonna give y'all some homework. Y'all need to understand the philosophy of probable cause, why the Supreme Court created probable cause, right? Understand the purpose and intent to do what? Understand that'll help you determine the philosophy to determine the legal intent and purpose. Then you go look at what the principles, and then the principles going to show you the elements. Right? You got to know the elements. Why is the elements so important? Because those elements determine if they met their threat, they not their threshold, did they meet probable cause? Did they meet probable cause? On its face, did they meet the elements necessary to sustain probable cause? They may say they met it, but the facts got to show. So if they violate rights, if you saying they violate your personal rights to do what? They can't break the law to enforce the law. You understand what I'm saying, family? Any more questions? Abdullah, any questions? Anybody got any questions?
I'm looking right now for the comment. We have a Lenape, Hoking State 2634. It's a statement. The standard of eliminating qualified immunity is measured under arguable, probable cause, and probable cause.
Read that again.
The standard of eliminating qualified immunity is measured under arguable, probable cause, and probable cause.
Qualified immunity is
Yeah.
based on,
Mhm.
is based on if the officer was within his scope of his duty, the gambit of his duty. How would you know that? How would you know the officer was in the scope of his duty? Do anybody know?
Everybody know? Put that in if you know. How do you know if the officer is in the scope of his or her duty? We got, let me see. The oath. Jeremy Bay, the oath.
Oh, him obeying the Constitution?
Said the oath. The written the oath of office, the oath of that they take. That's what the comment is written now. The oath. That's the answer. That's the answer that an answer I answer a person gave you to the question.
Their oath of office determine their scope. No. It has
No,
something.
that's not what you asked. You asked how would they know?
I mean, how would they know? Determine their
Yeah,
scope.
the qualified,
So they
within
take
the qualified immunity,
the
within the
oath of office to do what? Uphold the Constitution. That's what he's saying. They oath of office.
it says that's how you would know. To answer, you ask the question, how would you know if they're in the scope of their qualified immunity?
Because they took an oath of office, don't answer the question.
And then so that's not the answer then.
That's not the answer. So let's look at the answer.
All right.
Let's go get it. So how would you find the officers? Okay, let's go look at.
Question: how do you know if they're in the officer is within his or her qualified immunity?
Kenneth L. Bay said in a previous comment, let examine a police code of conduct booklet to see if the cop followed all the rules in the book.
No, he said what? Who said that?
It says Kenneth L. Bay
Obadiah.
7237. Obadiah said, oh, well, you know. Let's examine a police code of conduct booklet to see if the cop followed all the rules in the book.
Somebody been listening to King L. Bay.
So go into that, King. So
when the police they go through training and all of these different things, right? They got a code of conduct. The police they give them a manual. You tell them this is how you got to conduct yourself, and this is what you can do. They have a handbook, a police handbook. How you gonna know they within their scope? Ain't nobody cracked open that police manual. Who's reading the police manual talking about I know what the police duties is? Taking an oath just say I took an oath to the Constitution, I'm going to adhere to the Constitution. He's not an attorney though. So when they create those rules, what do you think they're supposed to have in mind when they created that code of conduct, the Constitution? Why? Because the Constitution set the foundation for everything else to be exercised. So they got to incorporate that constitutional principles within that code of conduct. Why? Because they're going out there serving the public and the interests. And they coming in touch with you. What do that mean? You got private rights that they don't post it, that they can't strip you from. Because the Constitution put a lock and key on that. It's a process that you got to go through. That's why it's called due process. First, he got to adhere. He got to know his scope of his duty. And you got to know that. If he did something without knowing the scope of his duty. So let's look at Cincinnati Police scope of duty. The Cincinnati Police Department scope of duty include a wide range of responsibilities aimed at protecting the public and maintaining peace. The key areas of focus is patrol, ensuring the safety and security of the community by patrolling neighborhoods and responding to emergency investigations and conducting investigations to solve crimes and apprehend offenders. Providing administrative and operational support to patrol investigations and supported bureaus. Right? It talk about certain things. Now let's go here. Cole, they got a handbook. They got a handbook. Cincinnati Police, remember I read this on the last one? Procedure manual and other body written directives. You don't remember I read that on one of the
No, you did. Just
we
just
went
do a review.
Everyone here might have not heard it.
Yes.
It says purpose to provide official guide outlining the way to do many of the routine operations which confront the police department. To provide efficient methods and high standards of procedural rules, regulations, and policies and directives recognized as official policies and apply on a department-wide basis. The Cincinnati Police Department procedural manual, as well as all other police department procedure rules, regulations, and policies and directives are used to maintain compliance with federal and state and local laws and ordinance, labor agreements, civil service rules and regulations, administrative rules and regulations, and personnel policies and procedure. The nature of all service is such that it is impossible to develop a procedure plan or other binding directives for any situation that might arise. Therefore, therefore, a district, section, unit, or commander have a duty of thorough reviewing the activities of subordinates, as they must assume the ultimate responsibility for defects and weakness in police work. You got to understand this manual, man. You got to go through your state and look at the police manual to determine that he follow all the steps in accordance to what he was supposed to do. How many of your lawyers are doing that? How many lawyers are subpoenaing that as evidence into the record showing that this comes directly from them and that they didn't follow the police manual?
we got a couple other copy that. Thanks, King.
You're welcome. So a lot of us, we're not looking at the whole scope of how to deal with this landscape. It's a lot of stuff that you need to understand and review. As a heavy litigator, this is stuff that I used to do. I'd be pulling all types of records, police manuals, FBI manuals. I'd be looking at different things, not so much. I'd be looking at agencies, policies, and procedures. I'd be looking at all of these different things. Why am I looking at these different things? Why am I looking at all of these? I need to see if they was within their scope of their duties. It ain't just about probable cause, because if they was out of conduct in violation of what they were supposed to be doing, how could they even state they was within the proper guise of probable cause? They was doing something they weren't supposed to be doing, something illegal in the first place. Oh, you wanted something?
This is good, y'all. Seating up. We got 20 minutes.
So y'all got to understand that. So if a police officer is outside of his scope of duty, like that's just like me being a nurse, right? If I'm doing something that I ain't supposed to be doing as a nurse, right? How could I justify any other actions I was doing? They can't break the law to enforce the law. So if an officer went beyond his scope to do something, to say, because he can't, so remember, we talked about reasonable suspicion. Do anybody remember what reasonable suspicion was? Do anybody know what reasonable suspicion is? Suspicion. Come on, help me out. I can't see the chat. Abdullah, where you go? If anybody can put in what is reasonable suspicion.
Someone said sounds like probable cause. Jeremy
No,
Bay.
it ain't probable cause, reasonable suspicion. It's more than a hunch. So, reasonable suspicion is based on a set of facts based on a police officer articulable knowledge. He got to have knowledge about a particular thing or what information based on some experience or something and it can't be a hunch. He got to have articulated facts. Probable cause is where he has enough, right, based on a statute that he say, well, based on this crime, we got enough for the evidence to go ahead and get a warrant. Search warrant, warrant for arrest, whatever. Reasonable suspicion is an officer got to have enough suspicion based on some articulated facts that he rely on because of his experience and years of experience, and it can't be based on a hunch. Like I'm gonna tell you one that they do all the time. They say, well, his what they say, his articulated artery was throbbing in his neck. He was super nervous. based on that, I based on my experience, when their artery is beating like that in their neck, that make and that the court let that fly all the time. They ain't even no physician. They don't know if you got a medical condition or not. But they'll use something like that to justify a search of your vehicle, hoping to find something. Find a marijuana joint. Find a seed, a weed seed in the car, marijuana seed. They'll say stuff like that he was acting super nervous based on my 20 years experience, 25, when somebody's acting that nervous and scared to give eye contact. They'll use some stuff like that. You got to know how to deal with it. You got to have enough understanding about this information. So y'all need to get these police manual and start going over this. Y'all need to form study groups in your community to know these things. Stop relying on certain things. Rely on a fact. Go get the police manual and y'all study them. Form a study group to know the scope of what these police officers supposed to be doing. You feel me? Stop relying on everybody else to give you information that you can go get yourself, and it's free. We are in the midst of their crosshairs and everything, but don't nobody do none of this stuff. See, knowledge is the key. See, when you can start looking at what's going on and start talking to them about what you know and showing them, hey, he was supposed to do this, this, and this, and this. See, now you can produce that. Now, when you produce that as evidence and you got what? The camera footage, let's say you got a camera footage of your car or whatever. You got a video camera on your mirror and in your window or whatever. And now you can say, look, when he did this, he was supposed to do this, 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 and this, and this, and this. He was supposed to have been doing this, 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 and this, and this, and this, and this, and this. But y'all can't say that because y'all don't read the manual. Y'all don't know what he's supposed to be doing. Because you don't know the scope of his duty. You're going to say, he took an oath to the Constitution. You know, the Constitution is so broad that the Supreme Court is still interpreting the Constitution to this day. They still doing it. There's certain stuff they still interpreting. But y'all, when it comes down to these rules, these manuals, you can directly look at these things and speak on these things because why? And present it as evidence. Why? Because it comes from a direct, credible source because they read it. They wrote it. When they pull you over, like I be seeing people, they be going back and forth with the police. Go get your sergeant. Go get your sergeant. I'm asking for a sergeant. Right? But y'all don't cite under the police manual, on the police manual, this, and the third. When I ask for this or do this, you're supposed to do this in response. Do you understand the rules I just read to you? Let me give you your police manual. You want a copy of it? I got an extra copy. I got it highlighted. I just went through this. This is what you're supposed to do. Why are you acting like this? Why am I getting treated like this? Y'all start getting the confrontation You ain't got nothing to get. You ain't got nothing to stand on because you can't cite no source of law based on the police manual. Y'all want to start arguing Supreme Court case law. Start with the very thing he's supposed to be following. This governs conduct more than anything in the police in the Supreme Court. Why do the Supreme Court? Because that's based on circumstances and everything. They got to review it. But this is a directive that he posted. These manuals is direct and upfront, person, close and personal that he has to follow every day, all day. But how could you challenge anything and you don't know that? You won't even start there. That's evidence. That you can go get that manual and say, I studied the manual, the officer was supposed to do this. This is an exhibit A. Under chapter A, B, you highlighted this was supposed to be done. Or they got it online, either or you can cite it off the line in the form of an affidavit that you read it, did this and that, learning how to preserve the evidence and take it to support your motion and cite the source in which you now can identify the officer's conduct. What he was supposed to do and perform while he was doing his specific duties. Am I making sense to everybody?
Absolutely.
You got to know what evidence is. You got to learn these rules. You got to know about the rules of procedure. You must understand, like, I've been doing this legal stuff so long that I do it in my sleep. I do it. Then I just be talking and I don't be picking up no books or nothing no more hardly. I just know what to do. I've been studying it so long. You talking about expertise. I just been doing it so long.
All right.
I've been doing it so long. It's in my DNA. I just do it all the time. I tell people, where you gonna start from? Now move his oath of office. Why? Why would you do that even for a judge? Why would you start with his oath of office? They got nothing. No, they got rules of professional conduct for lawyers. They got rules of judicial conduct. Why would you start with his oath when you can start with his, when he took that seat, he got rules of conduct that he supposed to follow. And that you can remind him under this, let's go to the judicial rule, because a lot of y'all be wanting to challenge the judge and all of this stuff, and that's the wrong way to challenge the judge. Right? So let's look at some of these things that his code of conduct that he's supposed to do when dealing with you in the courtroom. That can show biasness or prejudice.
Mm-hmm.
So, scope. An independent, fair, and impartial judiciary is indispensable to our system of justice. I want to say this again. An independent, fair, and impartial judiciary is indispensable to our system of justice. The United States legal system is based upon the principle that an independent, impartial, and competent judiciary composed of men and women of integrity will interpret and apply the law that governs our society. This judiciary plays a central role in preserving the principle of justice and the rule of law. Inherent in all rules contained in this code are the precepts that judges, individuals, and collectives must respect and honor the judicial office as a public trust and strive to maintain and enhance confidence in our legal system. Scope. The Ohio Code of Judicial Conduct consists of 4 canons, numbered rule under each canon, and comments that generally follow and explain each rule. Scope and terminology sections provide additional guidance in interpreting and applying the code. The application section establishes when various rules apply to a judge or candidate. So let's go down, let's understand what they doing, what they talking about. Let's go to Canon 1. A judge shall uphold and promote the independence, integrity of judiciary and shall avoid impropriety and the appearance of impropriety. So we need to understand what that means. Hold on, where is it? No, that isn't. Where did this come from? So let's continue. So these codes of conduct, right, when violated, can be used as evidence. What you mean? Because it's coming from a credible source. They did it. You can say based on this, Your Honor. It talks about disqualification. It talks about how he's supposed compliance with the law, promote confidence to the judiciary, avoid abuse of prestige of judicial office. So let's go there. A judge shall not abuse the prestige of judicial office to advance personal or economic interests of the judge or others, or allow others to do so. Let's go here. They got a bunch of this stuff in here. I know something. A judge should comply with the law. I'm trying to think. Comply with the law. So
we have 3 minutes.
There's one on here talking about he got to. I'm trying to find the one that with respect. Judicial protecting statements by judges. So let's go to ensuring the right to be heard. A judge shall, according to every person, has a legal interest in proceeding, or that person lawyer, the right to be heard according to a law. The judge got to give you a right to be heard. A lot of times they be trying to talk to you, over talk you, try to do all that fast talking, that slick stuff. You got to remind them, Your Honor, didn't you, under the judicial canons, don't you got to remember on the article, what article is that? Under the judicial canons, under 2.6, Rule 2.6A, that you got to give me a right to be heard? See, when you come at them like that, that makes a difference. You're not giving me a right to be heard. I'm coming with the judicial canons first. All I'm saying to y'all got to know the rules. Y'all got to know how to present evidence. These civil rules and all of these different things, the judicial rules, these are evidence that you can follow. The police oath of office, you got to take his police manual and look at what they're supposed to be doing based on conduct and everything else. This is how you navigate the legal system through knowledge. Based on fact, not based on theory. It's 2 hours, Abdullah.
All right. Man, wonderful job. Wonderful, y'all, both of you. Wonderful job. Thank y'all. Thank you, audience, for tuning in.
Before you go, I just want to give a quick
Yes,
recognition to
yes.
Okay.
everyone in the chat that's been participating. Also, Goddess Venus, Islam Empress. I would like to give recognition to Donna Valicia Mickens in the Ambrose Ward Mansion for the event on March 18th, the Know Your Rights event, and also the extraordinary family that I was able to meet, Latanya and Anthony, and their 11-year-old daughter, Trinity, aka Little Trin. I know they were in on the
They were
on
on.
the
Yep. So, all right.
I hope they're still on so they can hear me. They have an 11-year-old daughter that has written 12 books. She's an entrepreneur, a singer, a dancer, a gospel singer. She has a prayer line. Like this young girl is
Sundays.
very extraordinary. So I just wanted to give her that shout out.
Thank you, brother.
And we will have her on April 20th on
Yes,
Moorish Mondays.
absolutely. Thank you. Thank you. Yeah, they commented at 7:06. I did see that. Thank you for that. All right, thank you. My website, mooresandmasonry.org. All right, so we have next week in the house, live and direct. I've known since 2001. 25 years. She'll be in the house. Ross Mariah of RVBayPublication.com will be here next week in the house, live and direct. All right, she'll be giving us an astrology lesson. And after, so that's next week. And then we have Donna. No. We still in March. Ross Mariah will be here in April. Rewind. April 13th, Ross Mariah will be in the house. We have Donna Valicia Mickens this as a reschedule. Donna Valicia Mickens will be in the house next week. All right. I got ahead of myself. All right, she will be, this is the reschedule. She had technical difficulties. So she'll be with us for an hour next week. And I will continue the platform. But next week, 7 p.m. Eastern Standard Time. All right. So we have, like I said, so Donna Ross Mariah will be with us on April 13th. All right. Peace, everyone.
Peace.